Welcome to the Orientation Podcast Series from the University of Ottawa Faculty of Law Common Law section. My name is Professor Kyle Kirkup, and I'm the English Common Law Orientation Coordinator and co-host of this podcast. You will also hear on this podcast channel co-host and French Common Law Orientation Coordinator, Professor Anne Lévesque. We are both very excited to welcome you to the University of Ottawa Faculty of Law Common Law section. Each week, we will release episodes of professors at the Faculty of Law. Our goal is to introduce you to our law school community and to get you excited about the possibilities of your legal education. We will also have conversations on this podcast in both English and French. You can subscribe to our podcast on Apple Podcasts, Spotify, Google Podcasts, YouTube with closed captioning, or wherever you are listening to this episode right now. Professor David Wiseman is an advocate and researcher in social and economic rights, access to justice, and institutional competence of courts in charter litigation. Professor Wiseman earned his law degree at the Faculty of Law at Monash University in Australia, then earned his LLM and SJD at the University of Toronto Faculty of Law. Before joining UOttawa, he was a senior advisor at the National Judicial Institute of Canada. Professor Wiseman has also appeared before the UN Human Rights Treaty monitoring bodies on behalf of Canadian and Australian NGOs. In addition to teaching first-year law and upper-year access to justice at the University of Ottawa Faculty of Law, Professor Wiseman co-teaches the Access to Justice Lab Practicum course and is a joint coordinator of the JD program's Social Justice Option and the Admission Committee's co-chair. Outside the classroom, Professor Wiseman publishes numerous articles on access to justice issues and volunteers on the board of a community reintegration facility. Professor Wiseman teaches an upper-year seminar course called Law and Society: Access to Justice. In the course, students think critically about the role of lawyers and emerging technologies in addressing legal concerns. Professor Wiseman joins us today to talk about access to justice. Welcome to the podcast, Professor Wiseman. Thank you for being here today.
Thanks for having me, Professor Kirkup. It's great to be here and have a chance to talk about access to justice.
Great. So let's jump right in and let's start with the basics, the introduction. What does access to justice mean?
So there isn't as with so many things in law, there isn't a sort of consensus definition, and there's in some senses different definitions for different contexts. But I've recently been working on a research report about the role that non-lawyers can play in advancing access to justice. My co-author and I refer to that as community justice help. And for the purposes of that report, this is the definition that we use. Access to justice exists when people can pursue their goals and address their law-related problems in ways that are consistent with fair legal standards and processes, and can obtain, understand, and act on information and services related to the law where necessary to achieve just outcomes. So that's a sort of one paragraph, two sentence encapsulation. And there's a couple of layers behind that I could talk about if you want me to. There's that definition that I just read out is based upon sort of mashing together a few sources. One Canadian scholar, prominent access to justice scholar and legal professor, Rod MacDonald, did a study for the Law Society of Upper Canada, as it was then called, now the Law Society of Ontario, a bunch of years ago. And in that study, where he sort of examined a bunch of dimensions of access to justice, he identified three dimensions which I think sit behind and sort of inform that definition that I read out. So the three dimensions he identifies are procedural, substantive, and symbolic. So the procedural dimension is that achieving or attaining justice involves effective participation in the systems, both sort of formal legal and other sort of broader social and justice systems through which people obtain justice. It's substantive in the sense that the justice that they obtain needs to be really justice, like the outcome needs to be fair. And then the symbolic dimension, which I think is an interesting one, is particularly at this time, and by that I mean talking at a time when in Canada, we're very much addressing truth and reconciliation issues in relation to Indigenous communities, and then globally, Black Lives Matter is an important conversation in Canada and elsewhere. So this symbolic dimension is about adequate recognition of people and their communities within the sort of justice system as a whole. So in a way, it's sort of the next level up. So if you either can't participate effectively or you can't achieve fair results, then you're in many ways sort of alienated from justice and the justice that society is willing to offer. And so he calls that a symbolic sort of level of or dimension of access to justice.
So it sounds like it's a much more searching definition than just, access to a court with a judge wearing a robe, perhaps with a red sash on, sitting on high. It's a much more expansive approach to access to justice.
Exactly. And I mean, that I think that the thinking has evolved over decades around that. Certainly it began as a focus on, look, access to justice is about access to lawyers and access to courts as the main dispute resolution system. But it has evolved, and MacDonald also talks about that sort of thing in his study, and he identifies sort of waves of thinking and reform around access to justice. And so the first is that sort of access to lawyers and courts. Then he notes there's a second sort of wave looking at institutional redesign. So that's looking at the establishment of non-judicial tribunals. So, for instance, listeners might be residential tenants and aware that the landlord-tenant board is the primary process for resolving residential tenancy disputes. Well, that's an administrative board that is an alternative to courts, and lots of those are set up to try to improve access to justice for the participants. Another wave is a demystifying law wave that he talks about. So that's sort of public legal information, plain language, like getting law out to the people in a way that they can understand and therefore use it better for themselves. A fourth wave he identifies is preventative law. So where you're trying to think about the way sectors and particular issues can be regulated so that you can sort of anticipate and manage legal problems before they arise. So that an example of that might be, you might have a no-fault insurance scheme, or you might have, child support guidelines that are, they're the default. And if there's any, yes, there might be exceptions, but basically people know what the deal is from the get-go. And then finally, he talks about more recently a sort of proactive access to justice. So this is sort of both sort of spreading ideas of access to justice into all facets of our life, not just the facets that sort of engage disputing and sort of formal processes, but looking at what's happening inside a business or whatever in terms of justice claims within different sort of contexts. And then, for me, this proactive bit also means ultimately sort of flipping the lens to one of legal empowerment in a way. So you're trying to sort of bring justice into the community and make it part of what it means to be, a sort of citizen or a member of a community, and you're empowered legally to exist sort of in the world with the knowledge and the resources that you need to sort of navigate your life using law, sort of thing. So yeah, there's been a significant sort of deepening and broadening in the idea of access to justice. And the one other thing I guess I would just note on that is that it's very much not just about courts anymore. It is about administrative tribunals, but it's also about, how is legislation made and who gets to make legislation and that sort of thing. So it's about who's in the committee room when a piece of legislation is being debated, but also who's sitting on the committee, who are our elected representatives who are deciding that. So at a very broad level, making law is all part of, access to justice, and so there's been that has been brought into the thinking as well.
It sounds like in a lot of ways it's a project of trying to democratize the law. And I noticed that, a lot of your work has been about how we ensure that our incoming students and our students throughout their legal careers are thinking about access to justice. So can you say a little bit about why you think it's important for students to start to grapple with these issues sooner rather than later, as soon as possible?
Well, yeah. Well, one thing I would, that one hat I wear is as co-chair of admissions, and of course, as you're aware too, like all faculty are involved in admissions, and so when you're reading students' admissions files and their personal statements, a lot of students are already highly motivated and experienced in engaging social justice issues in their communities or in whatever discipline they come from or whatever. So, in some ways, there's certainly a contingent of students coming to law school who are already motivated around access to justice or around very closely allied concepts like human rights or social justice or equality. So for students who already have some experience or expertise, it's about sort of finding a place in legal education for those issues to be, still given importance and to deepen the understanding of it within that sort of legal context. And then, but, aside from students who already come interested in it, I think that, lawyers, people who are looking to exist, to work as lawyers or to operate in the legal system in some capacity, because of course, plenty of people go on not to be lawyers, but benefit from their legal training. If you're going to be licensed as a lawyer, one of the things when you swear your oath of sort of allegiance to the law, when you get licensed, one of the things you have to say is that you shall seek to ensure access to justice and access to legal services. Well, then you ought to know what that's about and what role you could play. Because lawyers, there's no question that lawyers play a crucial role in the justice system across all the dimensions: procedural, substantive, symbolic, and lawyers' expertise can be the difference between people accessing justice or not. But of course, one question is who has access to that expertise too. So I think that it's really important at this time for, at any time, but this time particularly, again, given everything that's going on, all the very prominent justice claims in society at the moment, lawyers are really called upon to think about what role they could play in advancing that. And so I think it pays to, from all those dimensions, to try and deepen your understanding of it.
Yeah, and so just moving a little bit now from the more definitional introductory to the more specific. So I'm thinking, one of the things you started to talk about was this idea of, everyday legal problems. So could you explain to our listeners what that means and maybe give us an example or two of problems that people face that may require resorting to a claim of justice or a legal claim?
Sure. So an everyday legal problem is something like the residential tenancy type thing that I mentioned. So it's defined. Sorry, I'll be. You can't. You can take the academic off campus, but you can't take academia out of the academic. Something. I don't know how that saying would go in that context. Anyway. So an everyday legal problem has been defined as an event or issue that happens during normal daily life that has a legal aspect and a potential legal solution within the civil justice system. So it's basically the sort of things that happen to people in their everyday lives that may not be entirely legal, like there might be financial aspects, health aspects, social aspects, whatever, but there is some legal dimension to it, and there's some dimension to it which could be, resolved or understood, or at least framed in terms of legal standards and processes. So, a dispute with your landlord about, being behind in your rent, or outstanding maintenance in your residential apartment is an example of a sort of everyday issue. But although that can be very prominent in any one particular person's life, there are other far more prominent everyday legal problems. So we know a bit about this from surveys that have been done in Canada and elsewhere, following similar models that try to understand what everyday legal problems people have, and sort of the prevalence of different types of problems and what people do to resolve them. And I should say, part of it began as a revolutionary idea to look at the problems that people actually identify in their everyday lives, instead of looking at what the court system does and saying, oh, well, we understand what problems exist by looking at what problems end up in court. Because as listeners, some may already know, and if they don't, they'll find out soon enough, that what the court system deals with is very much just the tip of the iceberg of sort of legal issues in society. So anyway, these surveys they typically find that the most prevalent sort of problems are consumer problems, debt problems, and employment problems. So examples of consumer problems are like, you hired someone to repair some goods for you, or do a repair at your home or something like that, and the repair was faulty, sort of didn't do the job. Or as a consumer, you purchase some services, travel, hotel, whatever, and it didn't meet the deal you thought you had made, sort of thing. So that's consumer sort of issue. Debt sort of issues are often about incorrect bills or invoices. So this is typically your cell phone bill is has an incorrect charge, your home internet bill, that sort of stuff, overages, all that sort of thing that you might dispute, or bank charges. Employment, health and safety issues in employment are actually the most prominent sort of within that basket, but it also includes unpaid wages, or denial of overtime, or unfair dismissal, that sort of thing. So those are the issues that are sort of typical everyday issues.
And I get the sense that in terms of how those typical everyday issues are resolved, based on what you've said so far, I'm going to intuit that the answer is that these disputes are not typically being resolved in courts or administrative tribunals. Is that your sense? That's
correct.
So where are people naming, blaming, and claiming law?
Right. Well, it's a good question. And what the studies tend to show is that most people do take action, some form of action, when they have some sort of problem in their life, right? Makes sense. But only about a bit under 20% ever seek sort of formal legal advice. So might go see a lawyer, or, in Ontario, a paralegal or someone like that. And an even smaller percentage ever end up in any sort of formal dispute resolution tribunal like a court. So that's always sort of less than 10%. So what people mostly do is, the good news is that most people will at least try to talk to the other party to try to work out what to do. People will often talk to friends and relatives, which, may be of mixed benefit. And then people will look online for information, or they will talk to some sort of community organization or professional association or whatever. So you might talk to your union, or you might go to the local community health center, where there's someone who might be able to join you, to someone who's familiar with a particular type of program that you need to understand better, to know whether you have an entitlement to it, or what credit counseling that might be available, or whatever. So people do take an array of sort of actions, but only a small proportion of problems ever sort of are brought to lawyers. And perhaps not surprisingly, then, that means that whilst over half of problems do resolve one way or another, a significant number of problems don't resolve, or they resolve in the sense that they're no longer a problem, but they were never really properly resolved.
So it sounds like then there's a lot of barriers to folks accessing justice. I think perhaps a prominent example is the growth of self-represented litigants, but it seems like the systemic barriers, are far greater than just folks who don't have lawyers in court processes.
Yeah, absolutely. And the self-represented issue is an interesting one because you know I think at the moment we tend to really think about that issue in relation to family law, and there's a sense that going to trial for a family law, usually it's a relationship breakdown context where people need to settle custody and access to children or property division. And you often see news reports about how expensive it is to go to trial for those sort of things, and that a lot of people are self-representing themselves because of that. And it's for good reason regarded as a real problem for the courts to sort of manage that. And there's proposals recently to expand the scope of licenses for paralegals so that they could help out with family law matters, sort of as a supplement to legal lawyers' services. But it's interesting if you put family law problems back into those surveys of everyday legal problems. Family law problems are only about 5% prevalence, whereas consumer problems are like 22% or something, and housing is less than family. It's about 3% or so. So it's important to keep these things in context, right? So we definitely regard self-representation in family law as a bit of a crisis, but family law is a very small, in fact, although very important, area of problems. So, and if we think about that a little bit more in terms of what other barriers are there, well, one of them is just that people can't afford lawyers, or at least they perceive that they can't. Obviously people are making choices about what they spend their money on, and often they perceive that they can't, even if maybe they could. There's not much. There's virtually no legal aid for family law matters. There have been some programs at some times, but that's virtually non-existent for family law. And even where it is existent in terms of legal aid, well, the financial threshold for eligibility for legal aid is extremely low. And then, it may or may not cover your particular subject matter. So that's, access to legal services. But then there's just issues about, well, you could sum it up as a sort of legal capability idea. So, do people understand, what legal issues arise when their relationship breaks down? Do they understand what their rights really are? Do they know what the process is for trying to resolve that? And so that's a lot about sort of understanding that you have a legal issue, understanding its significance, knowing where you could go to get help if help was available, and then on top of that, sort of being able to afford it. And this is all in the context of people who have very busy lives. We're all running a million miles an hour, 24/7, trying to cope in this sort of modern world that we live in. So there's those sort of barriers of just sort of understanding enough to join with the help that might be available, and it's not always available. And then there's equality, sort of social context issues cross-cutting that. So as soon as you are thinking about groups that might be, folks who are living on lower incomes or otherwise socially disadvantaged, or have experiencing racialization, or might have communication barriers, English or French not their first language, live in a rural or remote community. All those things then just compound not only the lack of access to sort of lawyers, but also the lack of access to knowledge and that idea of sort of empowerment.
So it sounds like, there's the monetary costs of an inability to access justice, but it seems like the societal consequences and perhaps even the mental health consequences are just as important to feature in the analysis.
That's right, because part of the issue about having a legal problem is that its sort of impact on a person is more than just the legal impact, right? Like it's stressful. Um, and it can have other costs. So part of what these everyday legal problem surveys are starting to do now is to sort of gather information on sort of what are the other costs to individuals of having a legal problem that resolves or doesn't resolve, and then also how does that compound on society. And often you might problems can cascade, for instance. So you might have a problem with your job that then becomes a problem with your housing, that then becomes a problem with your partner, that then becomes a problem with your kids and your car loan and all that sort of thing, right? So things can compound, and that can then create um, you know, emotional problems for you. It may exacerbate physical or mental health issues. So it can be quite a damaging experience for someone, just leaving aside the costs, and then that in turn can flow on to social costs. So you know, if someone unfairly loses their job or otherwise loses income, well, they need to claim EI, or they need to find out if there's a social assistance program available to them. And, they may go, though it's great that those systems are there, and that may help to get them through. But if they never should have been on that system in the first place because they've been unfairly treated, then that's a social cost that doesn't get recovered, right? And healthcare costs can be significant too. So there are some sort of numbers going around this sort of thing out of the recent Canadian survey, and what the survey sort of found in terms of big numbers was that the way they work them is that they ask survey respondents, okay, in the last 3 years, have you experienced a legal problem that you regard as significant and serious? So the survey is not about did you get a parking ticket or whatever. It's about, there's a certain threshold of seriousness of problem. And when people respond to that and identify the different categories of them, what they found in Canada, and this sort of reflects other jurisdictions as well, is that over like a 3-year given 3-year period, they expected about 11 million Canadians, adult Canadians, would experience at least one serious everyday legal problem, which is equivalent to about 50% of adult Canadians in a 3-year period, and amounts to something like 35 million everyday legal problems arising over a 3-year period. So that if that's the sort of number you're talking about, then these numbers about social costs then make more sense. So it's been estimated that the flow-on cost of those everyday legal problems to the social assistance system is about 248 million. To the employment insurance system, it's 450 million. And to the healthcare system, it's over 100 million. Now, and those are sort of ballpark estimates, but it's an attempt to try to understand what's the impact of legal problems and lack of access to justice for those problems, and it's clear that part of the agenda of this sort of research is to make the argument that we should be more preventative. We should invest in access to justice services now, not including lawyers and legal aid, but not necessarily limited to that, because ultimately that will, as a society and as individuals and a collective of individuals, that will save us costs, down the line. Now, of course, that sort of argument has limited, for whatever reason, continues to have limited appeal for policymakers and legislators. But at least we have some numbers now to sort of back up, what the opportunity cost is of doing nothing or not doing more for access to justice.
And many of our listeners will be incoming first year law students, and I know you teach property law. So, do you have any advice for how students can start to think about access to justice in their courses? I know sometimes I get feedback from students like, I'm just trying to figure out the three-part test right now, and at some point down the road, I will focus on these issues. So, do you want to make a plug for perhaps engagement as early as possible for our students?
Yeah, I mean, I absolutely would, and you know, if they're taking property with me, they won't, they won't be able to escape it. Although it's not all we do, but I think that you need to have a framework for thinking about how the law works in individual cases, and it's important not to get lost in the minutia of doctrine without sort of being aware of the context within which that's operating, in part because when and if people are practicing as lawyers, like that context can be 80% of what has to be managed in trying to advance the issue. I mean, a lot of tenant housing issues, the law is not complicated. It's navigating the process, gathering the documents, thinking about how you're going to meet with your client, how your client's going to understand and give effective instructions, how you're going to navigate the process. So you really need to be aware of the individual context of the client you're helping and the broader context within which they live. So and the systems they're trying to navigate in order to sort of provide effective help. So that's sort of one level at which it's important, the way that these issues sort of merge. But then, I think it is important for lawyers who are operating in all these contexts where they're sort of either perpetuating or seeking to reform the broader operation of the legal system. There's lots of opportunities for lawyers to be the person in the room when things are happening like that, law reform or sort of status quo, and it's important to know the broader picture of whatever it is that happens to be on the table in order to think about how that particular area should be managed or regulated or reformed going forward. So I think that I don't disagree that knowledge has to be built, and a core skill is that sort of legal problem solving, legal advice, but it doesn't really work, I don't think, to just sort of do one, park the rest, and then come back to it. I think it all needs to be developed in a incremental way throughout the 3 years, sort of thing. The way you do, the 3-part test is going to be different at the start of first year to the end of third year, and so is the relevance of access to justice and other issues to that moment, both in first year and at the end of third year. So I think those conversations need to continue in parallel, like
Is
it or
there?
not.
Yes, true. A final thought that you might have for our listeners on access to justice. What one thing that perhaps they could take away from our conversation?
Well, one thing, I guess, obviously, I think it's super important. And access to the idea of access to justice is not the only concept available in law to think about, the sort of issues it raises in terms of human rights. Obviously, human rights is an important legal concept as much as, broader sort of political concept, fairness, equality. Those are all concepts that bleed across different disciplines, but access to justice is potentially a sort of fairly unique legal concept, or at least the concept that should be uniquely important to lawyers. And it can provide a basket for all those other sort of substantive notions of justice framing human rights, equality, like that can be brought into access to justice in the substantive dimension, but it's only part of it. We got to remember the importance of participation from a legal perspective. So I think it's important because it provides a way to bring a lot of issues that are already important to students who are embarking on a law degree into the legal sort of their legal education experience. As I said, you don't have to squeeze everything into access to justice, but it's clearly a legal concept that resonates with those commitments. And I think that you can't escape the fact that the current experience of access to justice in society is deeply and alarmingly unequal. And it's not entirely untrue to say you're either part of the problem or you're part of the solution. And there's opportunities every day for lawyers and people trained in the law to be part of the solution. And so I think that students who are interested in that particularly should feel that it's an important thing to be interested in, and there's ways to pursue it and to develop your skills in trying to pursue it. Now, it's not easy. Nothing is when you're fighting to sort of change the way the world operates to some extent. But there are ways to sort of try to do it, and there's plenty of resources at the faculty to try to help with that. Although we're all in the same sort of boat. And the other thing that I think we need to remember, in the legal profession, is that like this lack of access to justice and inequality, like it's not an accident. Like the amount of access to justice that exists is importantly constructed over time through deliberate action. And, as one of our colleagues, Professor Kirkup, Professor Constance Backhouse has been a leading scholar over the years researching sort of the experience of access to justice in Canada, and as her work and the work of many others has shown, the legal profession itself, for instance, was highly discriminatory in terms of who it allowed to be a lawyer, and then more broadly, who could exercise legal rights. Of course, Indigenous communities were denied, the ability to hire a lawyer, let alone to exercise a lot of their rights that other people were allowed to exercise on a daily basis. And many other communities have been discriminated against deliberately, and that has created this lack of access to justice. And the legal systems, to the extent it hasn't done it itself, it's been complicit in it as well. So it's important to realize that in terms of thinking about the role of someone who comes out of a legal education as to some sort of responsibility to address those issues, I think.
Agreed. Okay, so last couple of lightning round questions before we close for today. What was your favorite part of law school? And you don't have to say your doctoral thesis at the University of Toronto.
I certainly would not want to say that. I think, okay, so my thesis wasn't my favorite bit, but I did enjoy, and as part of why I'm an academic now, I guess. I mean, I enjoyed wrestling with the way the law is and the way the law ought to be, and I've always been sort of motivated to think about that, and so I liked engaging that, both in my own mind and in conversation with peers, and what's so valuable is the community of other law students and professors, but so much of the value of law school comes from being educated in collaboration with other folks who will have different views and different experiences and different skills, and it's really important, I think, to try and benefit from that and explore that. And that was certainly something that that I thought was valuable about law school, because there is a sense of community, and I mean there can be a downside to that. It can I mean, I hope I'm not talking out of school to tell people that, there can be a certain element of, oh, this feels like high school again, or something, like it's weirdly sort of claustrophobic. That can, I'm not going to say that it's not an issue. Maybe it's less of an issue now because it's a while since I was at law school. But that's the downside of sort of being in a community that's working through a process sort of on the same staging. But the benefit is that there's a chance to collaborate, learn from each other, and learn together, which can be really valuable.
Well, thank you for joining us today. I learned so much about access to justice, and I know our students are going to be really excited to take your first year property law course, or perhaps an upper year access to justice lab or practicum or something.
Well, thank you, Professor Kirkup. It was great to chat with you, and I look forward to chatting with anyone, anytime about access to justice. It's great that I appreciate you putting it on people's radar this early in their legal education career.
Okay. Thank you.
See you later.
You've been listening to an episode of the Orientation podcast series from the University of Ottawa Faculty of Law Common Law section. You can subscribe to the Orientation podcast series on Apple Podcasts, Google Podcasts, Spotify, YouTube with closed captioning, or wherever you are listening to this episode right now. If you are a first-year University of Ottawa Faculty of Law student, you can also find additional sources at the Orientation 2020 Brightspace page. Thank you for listening, and we can't wait to meet you soon. This episode has been produced by Tech Law Fellow June Gleed.